All right, so this is chapter 4, and we'll be talking about patents and trade secrets. We discussed about copyright in chapter 2, trademarks in chapter 3, and now patents and trade secrets. So again, they are all different IPs. They are different types of intellectual property. They each protect different subject matters. And you may remember I told you a product may be protected by a trademark, so the company's name or logo, or even the product's name or logo, design, plus a patent on the product. So there may be a patent for how the product is manufactured, and we'll see some examples today. And the user's manual, for example, of the product may be protected by copyright. And there may be even some confidential information, some valuable commercial information related to the product that may be protected as a trade secret. So those are all different IP types, and they may alone or along with themselves in conjunction protect one product or service. All right, so what is the patent and trade secret chapter about? So we're gonna discuss the scope of patent protection and also understand the requirements to patent a product or to have a product patented, and then look briefly at the patent application process, and we'll end by looking at one international treaty for patents, and then look at trade secrets, so how they are protected. We'll be also covering defenses for patent infringement. And you may recall, or you may read in the news, last year, if I'm not mistaken, there was this major decision in favor of Apple in the United States for touchscreen. Apple was suing Samsung for patent infringement, and they won damages of about $500 million for patent infringement. But we'll also look at some defenses when we look at infringement. Okay, so let's look at the scope of patent and what is a patent, what a patent protects. So whoever has a patent on a product actually has the right to exclude, to prevent others from either making, using, marketing, selling, offering for sale, and even importing that invention, that product that is patented to the United States or to Canada. So the best example for a patent I'm going to use now is touchscreen. So I've just talked about this touchscreen battle, Apple and Samsung, but everyone or most people have a smartphone with a touchscreen. So a touchscreen is patented, and it belongs to Apple. So Apple has the right to manufacture the touchscreen itself, or to license their patent rights to others usually for a fee, usually for a right. So when you invent something, when you create something, you then have and you patent it, you have the exclusive right. And this exclusive right for a patent will be for 20 years. So remember we talked about copyright, and copyright was the life of the author plus either 70 years or 95 years, the protection. And then trademarks, 10 years, but this 10 years can be renewed indefinitely as long as you have been using the trademark in commerce, so you cannot stop using it. And now for patent, protection will be for 20 years. So after 20 years, you do not have this right to exclude others anymore. And one of the requirements to patent an invention is to disclose, to fully disclose what the manufacturing process is, what the invention is, how you make it. So after 20 years, everyone will be able to manufacture, to make your invention. Because when you applied, it was a requirement. You disclosed it fully. You disclosed the manufacturing process fully. This is very common for medicine, for drugs. So you may have run into this situation already. So you go to a pharmacy, you have a prescription, and then the pharmacist says, would you like to buy the brand name or the generics? So the brand name means, in most cases, it means the company that had a patent for that drug, for that medicine. But then it is not protected by a patent anymore, and others can manufacture the same medicine. But they cannot use the brand name because the brand, as we saw, trademarks, they last for 10 years. They can be renewed indefinitely. So that's why we are offered then the generics. So the generics would be in principle the same medicine, the same drug, but not under the famous brand name. And why do generics exist? Because other manufacturers were interested in products that were once patented but are not patented anymore, so they are into public domain now, and they are willing to manufacture them. Okay, so that's a good example of what happens after the 20 years. So it goes to public domain. And whatever you are about to patent, the requirements, they are quite strict. So your invention has to be novel, has to be useful, and has to be non-obvious. So novel comes to the aspect of you are inventing something. It is not something that you found. You are inventing. You are actually creating. And it is useful because it has use. It has mass application. If you invent something that only you can use, only one person can use, so it's not useful in a large scale. And it's non-obvious. Non-obvious meaning that if you compare to what already exists, that is known as prior art. So prior art is the comparable of your invention, what already exists. If you compare it, your invention to the prior art, it's non-obvious. So you actually had to apply your mind, to apply your expertise, creative capacity to come up with that invention. Okay, so that's those are the main requirements to have a patent. And by the way, when we discussed about copyright, so once you had it in physical form, it was protected by copyright already. You could register, It is highly recommended to register, but not required for protection. For trademarks, similar. So once you have a brand, once you have a logo, you are using e-commerce, so you acquire that brand, that trademark, it is highly recommended you register it. For a patent, this doesn't exist. For a patent, you have to actually apply for a patent right. So you fill out forms, you describe your invention, how you came to that invention, how you manufacture that, what is the process. And you can use graphs, you can use drawings, you can use any tools to make it clear how your product will be manufactured. And then based on the requirements, novelty, usefulness, and non-obviousness, the patent examiner will either grant a patent, will either grant you the patent you applied for or not. Okay? So, and one thing that is important here, let's say you invent something. So when you invent something and you make it available, so let's say you publish an article, you publish a research about your invention, you have up to 1 year to apply for a patent. If it goes longer than 1 year, your publication becomes the prior art. So if your publication, if your invention becomes a prior art, it is actually non-obvious anymore if it's 1 year after you made it public. So it's very, very important when you invent something, maybe you don't want to apply for a patent because you don't know if your invention will be successful or not, but you have to be very careful while making it public and the time you take to apply. And by the way, I won't go into many more details on this, but you can research on the USPTO, for example. There are provisional patents. So while you are researching, you apply for a provisional patent. So this way, you may be protected in terms of making your invention prior art. Because you may be, let's say, you are inventing a formula for a insecticide, for a chemical product, let's say, and you want to start testing it in crops, but and you don't know if it's going to be successful or not, so you're not sure you want to apply for a patent because it's costly. So what you could do is you apply for a provisional patent, and then you start testing it, you see some good results, and from that provisional patent, you make it to a full patent application. Okay? But the main message here is that once you make your invention public, again, you either publish it or you go to a seminar or you share with others, you have up to 1 year to apply for a patent to avoid that your invention becomes prior art. Okay? And who owns the patent? Well, first of all, the patent has to be granted. But who can apply for a patent? In the US, they have the first to invent doctrine. So let's say you invented something, but someone legally or illegally or intentionally stole your invention, or someone was working with you, you were the inventor, but this other person had access to everything and they went first to apply. This is not the principle in the US. The principle is the first to invent. So if it is the case that two people apply, let's say at the same day or different in days or weeks or even months, but the second to apply was actually the first to invent, and if there's evidence with this, so this second person in case the patent is granted, will be granted to this second person to apply. Because it's not how fast the two people individually apply, but it is actually who invented the who made the invention, okay, who created the invention. And when it's with companies, so in most cases companies, they because you are hired to do that, you are hired to research, to invent things. So in most cases you are the inventor as a person, but you do not apply. It is the company that applies. Because in most cases, in your employment agreement, you will be assigning all patent rights to your employer because you are being paid to invent them. You are using the employer's resources to make those inventions. So the employer would mostly be the one to apply for a patent and the one with the right for the first to invent. Okay, so keep in mind this first to invent doctrine, not the first to apply. It's not the one who is faster, but it's the one who actually invented. All right, so moving on. So we were discussing about this prior art a little bit. So the prior art is everything, in other words, knowledge, other patents, or even usage of your invention or something similar to invention that is already in existence, that we can find anywhere. We can find in our country, we can find in other countries. So our inventions, for them to be non-obvious, they have to be, they cannot collide with prior art. They have to be fundamentally different from prior art, from what already exists, from the knowledge that is already available, from other patents, or even other descriptions of processes or products. Okay, so let me give you an example here. There may be, so there's touch screen, it already exists. Now, eventually, they will invent a screen that responds to our thoughts, to our head movements, or even hands movements. Well, that is, it may be a bit obvious that this is the next improvement, but still, the functions would be different. So this would most probably pass the non-obviousness requirement. Okay, but if you have a touch screen and now you make a curved touch screen, but still the functions of touching and responses is they are the same, then the touch screen is already prior art because it already exists. Okay, so another concept we need to explore is the anticipation concept. So when a product, when a process is already known or used in other countries or even patented, so it means this invention is anticipated. And when we have anticipation of an invention, when there's prior art colliding, again, we say that, or the examiner will say that the patent cannot be granted because the patent will not meet the novelty requirement. Okay, so very important to apply for a patent as soon as you make your invention, and also research about other patents available or other publications, other inventions that are not patented yet, but that may be available because they may, because you may, or the inventor may have issues or problems with anticipation. Okay, so non-obviousness and novelty are the two main requirements to meet so that you can have your invention granted. Okay, very, very important. There's also usefulness. So I already explained to you, usefulness is related to being able to be used in large scale, not only for yourself. So if I invent something that only I can use, something I invented to drink my tea in a better way, or to prepare my tea in a better way, but I cannot make it in large scale, etc. So this is an invention I cannot patent. Okay. So we discussed about what a patent is, how we protect them. They go through a process, patent application, but now let's look at how patents can be infringed. And we have most 4 infringement types or categories. The first one is direct infringement. So this is straightforward because the patent brings its full description. So without having the patent owner's authorization, I use those instructions, I manufacture or I sell or I import a product, I market. So this is direct infringement. I'm doing what I can't. I'm using someone else's patent rights without authorization, without paying the fees, royalties, etc. Contributory infringement is related to making parts or pieces of the patent available to someone else to go into direct infringement. So here there's a third party in direct infringement, and I am the party under contributory infringement, helping, providing tools, parts, pieces of equipment to this third party that is the direct infringer. So this is contributory infringement. Induced infringement is very similar to contributory infringement, but now, and in induced infringement, I am not providing anything, but I am inducing. I am not only recommending, but motivating the party to direct infringe the patent of someone else. And then the literal infringement is related to the claims. So when we are describing in our patent application, when we are describing our invention, we will be making claims of what our product is made to, what is the use of our product. So those claims in a literal infringement, those claims, they are present. Even though the process may look like a bit different, the product may look a bit different, but the exact claims we had in our patent, they are being used in this infringed or allegedly infringed product or process. So the literal infringement is related to the claims we have in our patent, not necessarily the process itself, but the use, the end result of our product, of our process. And the doctrine of equivalence is it is derived from the literal infringement, because what happens is that some infringers, they would deviate a little bit from the literal language of the claim. So they would change very slightly from the original claim of the patent in order to avoid the literal infringement. So with the doctrine of equivalence, if the patent owner proves that such slight deviation was made on purpose, intentionally, just to get away from the literal infringement, then the infringement will most likely be proved. Okay, so those are the main 4 types of infringement, or you could even call 5 or 4, and then a subcategory, which is subcategory of literal infringement, which is known as the doctrine of equivalence. So now let's look at this case. This case is important because it brought a specific type of hearing to patent cases. So there was this case, Markman versus Western Instruments, and this case gave rise to what is known and called nowadays Markman Hearing. So the Markman Hearing is whenever there's a patent infringement case, judges initially they need to understand what the claims are. So again, you applied for a patent in your application, you describe all the process, you have drawings, you have charts, you have graphs, but then one of the most important parts of your application will be the claims. So what is the product about? What does it do? What is it used for? Such as medicine. So when a new drug, let's say a new drug for COVID-19, when it is invented, when it is discovered, so it will be used to boost the immune system or to kill the virus or to kill infection. So there will be claims on that. But judges, they don't understand of the very different fields in terms of claims. So they don't understand about a claim on chemistry for a drug, claim on electronics for a touchscreen, for example, surfaces, etc. So initially, before the judgment, in a patent infringement case, the judges, they will hold what is called this Markman hearing, which is the court getting evidence and arguments that will help them construe the correct interpretation of the claims. So the question here is, how should judges understand the claims of the patent? So they will gain such knowledge, such tools during the Markman hearing. So in the Markman hearing, there will be specialists appointed by both parties, the patent holder and the alleged infringer, and they will bring evidence, they will bring arguments, technical data, information, etc., to help judges make the proper construction of the claims. So once the claims are properly construed, are properly interpreted, they become questions of law. And then judges will decide if those claims were used by the infringer, if there was actually a patent infringement or not. Here we're also mentioning about the decision of the USPTO. So if you have an invention, you apply to the USPTO, the patent office, and then the examiner may deny your application because you do not meet the novelty requirements, or it is obvious, so you did not meet the non-obviousness requirement. You may appeal the decision to the USPTO appellate body, or the BPAI. And then if in the appeal within the USPTO it is further denied, you can seek judicial review. So you can bring your case to courts, and courts will decide. By the way, there's a very interesting case, Amazon case here in Canada. Back in 2010, if I'm not mistaken, Amazon applied for a patent for a business method. Their business method is the one-click purchase. This is a business method, and they had the patent for it in the US, and they applied here in Canada. But here in Canada, business methods could not be patented. So what Amazon did here in Canada, they went to court, federal court, and they were looking for judicial review of the patent office decision to deny their patent application, and they won this case. So now, based on case law, on this Amazon case, business methods can be patented in Canada. It could not before. Okay, so it's just sharing this interesting case with you. So just sharing here this case from the textbook, so you have the full, not the full case, but you have a more detailed um, case text or wording in your textbook. But this case is related to Google's AdWords. So there's this company named Bid for Position. They developed a system or software that is similar to Google's AdWords. So what is Google AdWords? It is that ads, they are displayed in the top of the page when we make a search. So this company had this system called the Online Auction Bid Management System and Method. And then they thought that Google had infringed their patent. And the courts decided that no, Google's AdWords is different from their system and method. So just sharing this interesting online patent case. Moving on, so the requirements for patentability we discussed already, so just reviewing it a bit. Your invention must have occurred so before anticipation, meaning nothing exists before, because if there's a patent before, if there's knowledge, if there are descriptions related to your invention, it is not actually an invention anymore. Okay, and so it cannot collide with prior art. And prior art is everything that exists. So we discussed this already. And the first to invent doctrine, we also discussed this. So it is not the first to apply, but it is actually the first to invent. So who actually invented or made the invention? How do you apply for a patent? So you apply through the USPTO and you fill out several forms. I told you that for trademarks, it is very common that people apply for trademarks themselves online. If it is a small company, if you're starting a company, you can do it yourself. You usually don't hire a trademark agent. But for a patent is different because, again, you have to meet the novelty requirements. It has to be non-obvious. You have to describe it fully, full disclosure of your invention. So extensive research may be required, wording for the claims, for the description. So it is highly recommended to have a patent agent, patent attorney, a specialist in patents to help you apply and fill out all forms for a patent application. And at the end of the day, the patent examiner will examine for the requirements. The examiner may need more information, instructions, so there may be some negotiation with the patent examiner in a way that you establish you are meeting all the requirements to have the patent granted. And the last part here for a patent is related to the PCT, the Patent Cooperation Treaty, also mostly known as PCT. So the PCT is an international treaty that facilitates the international application, or the application, your national application internationally. Because remember, all IP types, they are national in scope. So there isn't an international patent. By the way, there's already an European patent because of the European Union. But this is new. This is the only region I am aware of that have a supranational type of patent. This is not common. What is common is, as I told you, IPs, they are national in scope. So you apply, like Amazon, they applied for the one-click business method in the US, and then they also applied here in Canada. They had it granted in the US, but not here. They sued and they managed to get the patent. But the PCT, what does the PCT do? The PCT makes it easier, smoother for you to apply in other countries in the future. So remember, you have the prior art. So let's say you have your invention now, and if you apply here in Canada, and then you decide to apply 2-3 years later in another country, you may not be allowed because your patent may already exist here in Canada. So it will collide with the prior art, with the novelty requirement. So what PCT does is you apply for a patent and then you also opt in for PCT. When you opt in for PCT, you are saying that you want to apply in different countries, but not now. PCT will give you up to 36 months, 3 years, to apply nationally, so in other nations, in other countries, for the same patent you are applying here in Canada or you apply in the US, but in about 3 years' time. And you can decide what countries you will go to. And with the PCT, that is also organized by the World Intellectual Property Organization, WIPO, they will also help you with international research. And it may be easier for you in terms of, you may still need to translate. It's not as smooth as the Madrid Protocol for trademarks, as discussed in Chapter 3, but still, it helps a lot in terms of the system. And most importantly, the PCT helps to stop the prior art, the novelty requirement, because you are already applying here and informing that you want to apply in other countries. So PCT has 150 contracting states as of now, and it doesn't mean you need to apply in all those 150 countries, but you may decide in which countries you are seeking protection for your invention. Okay, so very, very important treaty in terms of trademarks. Okay, so now let's look at trade secret. So what is a trade secret? Trade secret will be any formula, processes, devices, or any business information that puts your company in an advantage, in a competitive edge towards your competitors. So anything that can put you in advantage over competitors could be a trade secret, as long as it is kept as secret, as long as you are the only one knowing that information. One thing that is very, very important here: no one owns a trade secret. The trade secret, the information that is kept secret, is not owned. Let's think about a Coke secret recipe. So Coke doesn't own that recipe. They keep it secret, so it's only Coke using it. And this is the beauty of trade secret. As long as you keep it secret, as long as no one can find out what your secret is, you are using it as long as you want, as much time you want. So like Coke, they have been using their secret recipe for over a century. And other companies have used reverse engineering, uh, a lot of chemical processes and methods, but they could never find out what the Coke recipe is. And well, I'm biased to say because I'm a Coke addict. There's only Coke, and it's okay if you like Pepsi, but Pepsi is different. Coke is Coke. And here it is also interesting to contrast a trade secret with a patent, because Coke could have applied for a patent 1 century ago. However, if they had done that in 20 years, back in the 20s, their patent would have gone into public domain. So Coke decided to keep it as a secret. Yes, they ran risks. They still run risks, because if that secret is revealed, it's not a trade secret anymore. But after 1 century, they have already proved that they are competent and successful in protecting their secret. So you invent something. While you do not apply for a patent, you should keep that as a trade secret. But now you want to go to business with your invention. You still need to make a decision. Will I apply for a patent, spend all fees, monies, apply internationally, etc.? Or will I keep it trade secret? One way to help come to this decision is that when you think about how will others find out my secret? How can others find out my secret? So if you invented something that can be, if not easily, but not so difficult, not in a so difficult way, found out using all methods, all technologies that are available nowadays, so you'd better go for patent application, because you cannot keep a secret. If others have access to your product, they use whatever technologies they have and they find out how to make your product. But as in the case of Coke, for example, even though others have attempted hundreds, thousands times to find out how to make that recipe, they were not able to. So if you believe your invention cannot be found out, the process to make it, how to manufacture your product, then you should keep it as a trade secret. Your highest burden will be to keep it as a secret. Like Coke, they kept their recipe in a vault in a bank in Georgia. I'm not sure where it is now. And I read that only 2 people in the company would know the recipe at a time. They would never travel in the same airplane. So there's no doubt Coke has been very, very successful keeping that trade secret. But again, they don't own the information. They have competitive advantage. Why? Because they keep it as a secret. Okay? And in the US, there's no federal law for trade secrets. So it is all governed, trade secrets are governed by state law, but they came up with this Uniform Trade Secrets Act, the UTSA, which is a model law. So it's a type of a code that all states use, or most states use, meaning that rules, they are similar within all states, in all states in the US. And other examples for trade secrets, so customer lists, prices could be, let's say, prices, supply prices, costs, processes, software could also be manufacturing concepts. So everything you keep as a secret that brings you competitive advantage towards or over your competitors, they can be regarded as trade secret. Okay? And how do you protect them? Well, you protect by keeping the information in a vault, or if they are stored online, you have firewalls so that others do not hack into your database. You can also monitor the use of your database users, and to avoid invading their privacy, you should inform them that you'll be monitoring everything that is under the company's system or internet connection. You can also use encryption when you are sending secret information to others. You can have it encrypted. You must actually use confidentiality agreements with clients, with employees, with all stakeholders you have contact with if you are dealing with trade secrets, because it is it is keeping the information secret that is valuable. It is not the information itself, because once it becomes public, you have no rights over them. You have to keep it secret. Okay. So that's chapter 4, discussing patent and trade secrets. So we discussed what a patent is, the requirements to patent, how we patent, there's an application for it, the novelty, usefulness, and non-obviousness requirement. We also discussed the prior art. It is important to keep prior art into consideration so that your invention is not anticipated. And then we also discussed the infringement, defenses for, or types of infringement, not types of defenses, sorry. So the direct infringement, contributory infringement, induced infringement, the literal infringement, and the subcategory of literal infringement being the equivalence doctrine. Talking about doctrine, we also saw that the inventor is the first to invent, not the first to apply. And we briefly discussed about PCT, the Patent Cooperation Treaty, making it easier to apply internationally. And we ended with trade secrets, Coke, one good example, KFC's sauce, another example just came to my mind. The trade secret itself is not owned by anyone, but it is valuable because it is kept as a secret and no one can find it out, even using all available technology. So those are the main chapters for IP in this course: copyright, trademarks, patents, and trade secrets. Moving on, we'll be looking at other issues in internet law, cyber law, and technology. Thank you.